I'm delighted to welcome you all here to listen to the discussion that we're going to have around university law clinics and pro bono. Obviously mindful of time, I'm going to give you a brief introduction and then hand over to Sue, who will then take it from there. But for the main part of the session, we're very much hoping to hear from colleagues in the room regarding their experience of law clinics, and in particular to note and pick up from the speeches that we've already heard this morning, that importance of continuing the innovative work through not just innovation, but also through legal tech that is taking place, as we know, in universities and law clinics. So law clinics have always had a tremendously important role in filling those access to justice, legal aid, advice deserts that have existed for the past 25 years and have which significantly grown larger and larger as time has gone by. We used to talk about a concept of the rise of the university law clinic. It used to be the case that just a fair few universities would offer a small legal advice provision, which has grown exponentially in response to the ever widening cost of living crisis, external operating economic environment, and in terms of the general pressures also that now universities are facing in terms of resourcing those vital law clinics. I think it's fair to say that the majority of universities now would say that they have that provision in place, and it plays a vital role in our civil justice system, creating that unmet legal need. But as with any sector, the higher education sector is under a significant amount of pressure and is having to turn to increasing innovation to do more with less, or as I sometimes describe it, to do more with absolutely nothing. And so that's where the innovation piece has come along, alongside the growth of AI and legal tech. There are some very interesting models out there, not just in the United Kingdom, but also internationally and globally. And yesterday we were pleased to hear, and we will all hear again, from Director Rachel Rossi in terms of the innovations that are taking place in the US. Sue is going to give you some specific examples of innovation that she personally has experienced, both at her own university, the University of Exeter, but also from abroad as well. So I'm giving Sue that 5-minute nod to know that I'm going to hand over to her to talk us through some examples.
Okay, thanks very much, Liz. Hi, everyone. My name's Sue Prince. I'm a professor in the law school at the University of Exeter. I have experience myself of setting up and running law clinics. I set one up at Exeter Court a few years ago. I suppose the thing that has just happened with our law clinic, and it's a very popular law clinic, we have a lot of students taking part, but I've been made aware that in the last couple of days the university have started a fundraise for that clinic, and so you know, the issue of resource is obviously very important, and you know, we need to finance it, but there are advantages to universities and law schools in having clinics, but sometimes when you are up against it financially, then some things have to give. And although we have in Exeter a massive amount of unmet legal need, certainly in terms of the area that we're in, we don't have any sort of law centre in the whole of Devon or Cornwall. I think we have something like 2 legal aid firms. And so the work that the University Law Clinic does is obviously very important. I just wanted to, before we invite you to speak, and to introduce the idea of the theme of this particular conference, and in terms of working together and especially partnerships. And I've been looking elsewhere at other examples of clinics to see what we could learn from other jurisdictions. And I just wanted to give a couple of examples from Australia. So the first example is a policy example, and to do with resource. The Australian pro bono services model that exists in Australia says that law firms who wish to provide legal services to government must be a signatory to the Australian Pro Bono Centre's National Pro Bono Target. And that means that those signatories agree to use their best efforts to provide at least 35 hours of pro bono services per lawyer per year. And that isn't any pro bono services, those are specified pro bono services within certain criteria. So it isn't that a law firm can just say, I'm just going to go and do anything that I want. It has to be within the criteria of the pro bono centre. In 2024, this has delivered 20,000 lawyers doing 780,000 hours of pro bono. And I think what's interesting here is that that has often meant that law firms are working more directly in partnership with students and with universities. And one of the interesting innovations that's come out of that project is that many larger firms use the opportunity to create dedicated pro bono roles or even set up pro bono clinics themselves, which may be working in partnership with students. There's something like 168 reported dedicated pro bono roles. So what a large law firm might do is take all of those hours, pro bono hours, and give it to one lawyer who becomes their dedicated pro bono lawyer. The initiative has led to a rise in dedicated pro bono work, and the aim is to complement government legal aid, certainly not to replace it. But here we've got an initiative where we've actually got an incentive for law firms to think about how that they are going to contribute to pro bono and potentially working in partnership. And I suppose the question just to throw out to everyone is, do you think a similar enterprise would work in the UK? The other initiative is also from Australia. It's something that I've seen in practice. It's an innovative, free, not-for-profit online enterprise run out of the state of Victoria. It's an online service offering housing advice supported by students called Annika Legal, which has won several awards. And it was set up as a startup by an entrepreneur called Noel Lim, who was a law student, and it operates through academic partnerships with universities in Victoria. So it's not a model whereby the law clinic is based in the university, it's based in the startup, but the students come and work through that startup, and it is all online in terms of the help that it offers. It has those academic partnerships with universities, but it also has commercial partnerships with law firms and other firms, and also philanthropic partnerships with donors, and also community partnerships. So, you know, we might have some of those, but the numbers of partners that they have is quite impressive. Most of their funding comes from private grants as well as donations, and also obviously the university customers. And their service has won a number of awards for its online presence and its innovative model. It's created its own platform for the service that it operates, and that itself has won awards, and also fits into their commitment to advancing social justice through technology. So as well as developing services for people in need of housing support, and also offering support for students to develop their skills, it's also advancing legal tech through social justice. So it's got other arms to what it's doing. So I think that's an interesting model in terms of innovation, and an interesting model in terms of the future of clinic. And I think what we want to do is enough of us talking, really, and invite all of you to give us any examples that you've heard of. We'd like to hear about what you think about funding models and potential for funding, and also innovative platforms that you're either developing or involved in, or that you've heard about equally in other jurisdictions. So thank you for listening to us. We have a volunteer already. Do you want to introduce yourselves when you get the mic so we know who we're speaking to?
Sure. Hello, I'm Rebecca Wilkinson. I'm the CEO of LawWorks, the Solicitors Pro Bono Group. So I just wanted to pick up on the first point you raised, because, and I'm trying to think back when it must have been. I wanted to say 5 years, but it was pre-Brexit, so it must have been 9 years ago. We had a meeting at LawWorks with about 20 of our members, which were law firms and in-house teams, and a number of Ministry of Justice officials, to talk exactly about that issue in terms of how government procures legal services, and whether they'd be interested in even investigating what was going on in Australia. Now, at the time, the reason I know it was before Brexit is the government said they felt it would go against EU competition law. And one of the firms quite nicely said, we're willing to do pro bono work to explain why we don't think that's true. But anyway, the government clearly wasn't interested at the time, the civil servants weren't. But I do think, you know, obviously, we're in a new age. We're not in Brexit anymore, and we've got a new party in power. And certainly this was something that was discussed with the Solicitor General at a recent meeting about pro bono. So I think, I'm not saying let's run forward at pace, but I think it is definitely a new window of opportunity to discuss that. And Elizabeth and I were at a breakfast yesterday morning with Justice Rossi from the Director Rossi from the US Justice Department. And she was also talking about a scheme that they run, which is around government lawyers and their ability to do pro bono, because that's often problematic to do with conflicts and the way they've got around that. And I think possibly there's a nice thing for those two to go hand in hand. If government is thinking about it in terms of how they procure other services, what are they doing with their own legal services and pro bono? So that was just on the point that you were raising.
Thank you very much, Rebecca, for saying that. I think that there is a mood potentially for developing some of this, and I think exploring other ideas. Why wouldn't we want to explore further and see what's possible? Who would like to go next?
I'm Tony Martin. I'm head of clinics at PPP University. I think one of the things that's been interesting for us is the delivery of online clinics, which the pandemic forced us to move all of our clinics online. And I think we envisaged that after the pandemic, things might return to just face-to-face clinics again, with the occasional request for online clinic delivery. But we did a lot of research amongst our client group as to what they wanted at the time, although we were aware that when we were doing the research, it was mostly about amongst a client group that was receiving online advice. But actually, when we look across the clinics, and it does vary. I mean, we run 5 different clinics in 5 different areas of law, so it's quite complicated. And we are also a university that's complicated in terms of our structure, in that we have campuses in Leeds, Manchester, Birmingham and London. But actually, in the enterprise clinic, for example, 100% of clients, almost 100% of clients want online appointments. But even in a clinic like the Welfare Rights Clinic or the Housing Clinic, it's very much a minority of clients that want a face-to-face appointment. They around the 20 to 25% mark in those clinics. And it's been very interesting how many clients can cope with not only an interview online, which is relatively straightforward on video, and most people probably use Zoom or whatever to call family members post-pandemic, but also the delivery of documents online by uploading them to a system, or at worst emailing them, having taken them on the phone. So I think there is that appetite for it, and obviously we recognise, and you have to recognise, that there are some clients that will not be able to cope with that, and you need to maintain a face-to-face option for those clients. But I think it's been very interesting, that development, which is client-led, not led by us.
Thanks very much, Tony. Yeah.
I mean, I still think we're not doing enough to kind of realise the opportunities that the changes in the legal training system offer for pathways of development and pathways of training and career development through working within clinics and citizens advice and law centres and non-profit organisations as part of the either SQE or solicitor apprentice training and pathways. There were lots of kind of small initiatives here and there with different partners with different law schools, but given that the sort of SQE is such a kind of it's very kind of modular thing that can be adapted to to different ways of working, but it's kind of for us as a sector can then take that forward and kind of create and develop the pathways that can go through clinics, through not-profit organisations, then into the legal sector, and I think that's sort of happening on a kind of more systemic level.
Thank you. Yeah, I would completely agree with that point. I think the part of the policy decision making in introducing the solicitor's qualification examination and the qualifying work experience has certainly given higher education providers and private providers the opportunity, and also the SRA did take steps to deregulate to the extent that students could, in order to break down those barriers to entry to the legal profession, could get their 24 months by working in a maximum of 4 law clinics. And I agree with you, absolutely, that it's something that has begun to be explored by universities, but universities' responses have been varied to the extent of some universities maybe taking a step back and saying, well, yeah, you're working in our law clinic, but we're not going to sign it off as QWE, to the other end of the spectrum, with some universities guaranteeing that you will get 4 weeks and that will count towards QWE. So there's probably something in the middle there in terms of opportunities for growth that we could definitely explore. So I think that's a really valid point. Thank you very much. I think I could see some hand at the back there.
Andy Unger from London South Bank University. We have a large social welfare clinic and a number of smaller clinics, but also I teach law and technology, and I think we're getting tantalizingly close to solving the minister's experience with Google, though we're not there yet. But we work with a charity called Access Social Care, who've created a very useful chat bot that does a very limited job, but a very useful job. It will allow a client who would like access to local authority services to explain to the chatbot what they want, and the chatbot will create a letter that they can send to the council explaining their case in legal terms. And that takes work away from expert advisors who can pick up the thread if they don't get a positive answer. And we're using custom GPTs. We're developing them to give the students feedback on their coursework without writing it for them. And I think that we're getting to a point where you could usefully offer online initial advice, diagnostic advice that could be used by front-line advice services. And the problem, it seems to me, in developing it is partly how advanced the technology is, but also there's a cultural problem. We're all working in different ways. There's lots of people who are too busy to make a start, suspicious of technology. Everyone who's got technology is trying to sell it to you. I wonder whether there's not scope for a strategy in which we might settle on 1 or 2 pieces of tech and start building a system where there were, under the legal aid scheme, perhaps second-tier advice centres with expertise in housing law and employment law, and part of their brief is to build and update the tech resources, and then the frontline advisors, either people can access it themselves, or university clinics and other charitable frontline advisors and pro bono services might use those tools to give advice. Difficult cases get referred up to. But I feel like we still don't have a kind of coordinated effort to harness the technology for access to justice. And I think it needs some intervention. At the moment, we're just letting things happen.
Thank you, Andy. That sounds really exciting. And I think there is some nuances there and themes that draw from the work in Australia that I mentioned, Annika, and that sort of idea of a sort of central hub rather than each university doing their own thing, and thinking about how we might use that more effectively to provide help. And yeah, definitely sort of nuances of that happening. Great to hear. We've got a couple more at the front here.
So it's your use of the word hub that causes me to speak, and the almost the competition between various advice agencies. And I want to talk about the potential role of the courts. I'm a circuit judge. And in my court, we managed to set up what we called an info hub, where all of the interesting agencies come for 1 day a week. And now the advantage of that is, A, the students have court experience, B, the users feel that it's relevant because they're in a court setting, and often they're worried about court proceedings, or they're in court proceedings. But most beneficially, we call it the info hub, and if one agency can't help, they can be signposted to another agency. And the big struggle that I had was trying to get the Citizens Advice Bureau to come along. They managed it in Hull. Not managed it in my former court, I'm now retired, Sheffield, but we're hopeful that there's going to be a move there. But the advantage of having all the agencies in one place, one day a week, and the students having that sort of exposure to a real court is really valuable, we found.
Thank you very much for that. So is that Sheffield Court where that's initiatives happening?
Yes.
I think I set up, as I mentioned earlier, a law clinic at Exeter Court, which is a smaller court. And one of our problems was that we were just too successful with that sort of idea because we were overwhelmed with people and there was just so much work. It was too much work for a university law clinic. And so that became, very resource heavy. But I think now that was quite a few years ago. I think what you're talking about and that model of partnership sounds excellent. Thank you. There was another hand up over here. Yes, yeah.
Hello, I'm Hugh Evans, and I'm a private sector provider of legal technology. My company is called the Advisors Toolbox, and I've recently had a number of discussions with people involved with law clinics about the use of my technology within those clinics. It's not dissimilar to the Access to Social Care app. But it's got a focus on housing, welfare benefits claims, and homelessness applications. But yes, I'm keen to see it's coming into some law centres in the future. And I didn't make it for law centres. I made it primarily for citizens advice centres, but I'm interested to see it in law centres too. And yeah, happy to work with people and discuss this. Thank you.
Thank you, Hugh. That's really interesting to hear, and it'd be good to see more about what you're doing. So I made a note of that. Thank you.
Hi, I'm Q1. I'm from Freshfields. Prior to working at Freshfields, I was at a firm called Clayton Utz in Australia, so I thought it could be beneficial for me to just share my observations. And I agree with what you said. We do exactly what you described. In fact, the lawyers were required to work 40 hours of pro bono every year to meet our regular targets. And I certainly had opportunities to work with local universities. For example, in Canberra at the Australian National University to assist in their pro bono work. For example, helping Indigenous students find opportunities in the legal profession. So I think arising from that, my observations are that certainly our practice in Canberra was entirely focused on helping government clients. And I think I understand that that is a difference between Australia and the UK, that in Australia, a lot of the more complex and large scale matters, government matters that is often outsourced to private sector firms. And the private sector firms provide Commonwealth rates. So I suppose the question would be for the UK, would the government be open to doing that? And then also, would the firms here consider that sort of work profitable, especially having regard to the significantly higher hourly rates here?
Thank you. That's really constructive, and I think it's the model as much as anything else. And those questions you ask, I think, are really valid. But we, potentially having that debate, just discussing what that might mean for a different jurisdiction, would be interesting.
I'm a district judge at Manchester family and civil and previous act for legal aid lawyer dealing with the most disadvantaged people in the Blackpool area, which has, I think, 8 or 9 out of the worst wards in the whole country, out of the top 20. Nothing that we're particularly proud of. We had Manchester University, we had Salford University, we had the now called the Support Through Court with permanent offices at our courtroom. They have now gone. Funding has been withdrawn, although you can't go to the university law clinics, and you can go to or phone up Support Through Court, who will come to court. So the only thing we now have, which is really good, is a possession duty solicitor, where mortgage possession and rent possessions, there is an access to a lawyer who, to give them credit, are very good. But again, we haven't got enough legal aid lawyers in the area to cope with the demand. So I'm really impressed that Hull have managed to keep it going, but unfortunately we have not.
Thank you very much for raising that, and you mentioned obviously the cuts to the funding that I know impacted not just in the Northwest but nationally, and also the amazing work that Support Through Court still continues to do, and has been incredibly innovative in creating different models to ensure that at least there is some form of provision there. And I suppose that's where we came from, that starting point of understanding that funding model that we did have has shrunk beyond all recognition, and new areas, horizons that we do need to push and to nudge and to explore to develop alternative solutions. I don't think we pretend to have the answers, but I think we are quite clear that the time has come to look more broadly, more widely, and across continents, to the point made by the gentleman from Freshfields in terms of the Australian model, and obviously in terms of our models of partnership. And I think for me, it is that collaborative, that partnership aspect that is coming strongly to the fore. We're seeing an increasing number of these collaborations, as Graham mentioned, in terms of bringing everybody together in the same room, not dissimilar, if you like, to in America, the drugs courts that they have as an example, and just referencing back and again to the keynote that we'll have later from Director Rossi, some of the collaborative working that they do over there in the States. Do we have, so if we take this, I'm sorry, I can't see this gentleman. And then we might just ask if anybody online has got any contributions they'd like to make as well. So over to you.
Yeah, so I'm Subhendu Sekhar, and it's very interesting to listen all the opportunities that is being done here in United Kingdom. So basically, I'm from India, and I'm a research student at LSE right now, doing my master's in criminal justice policy. But back in India, I am CEO of my organization, Law Foundation, and we work basically with the communities, and particularly we provide pro bono services. So basically what I wanted to share is that in our community, what we decided is that whichever universities were there operating in that society, we thought of creating a collaborative network, and the university students took very active role in it. And thereafter, when obviously funding is huge issue, not only in different countries, but worldwide. So the communities themselves, after being served by the university law clinics, they decided that it is one of the most important aspects, because university students not only understands their problem in a better sense, but they also have enough time and empathy to understand the problem better. And as a result of which, when funding was a huge issue, the community itself came together and supported with the limited amount of funds that they had. And currently it goes around with the community, and basically we provide the pro bono services, which was started by different other funders, but now it is being supported by the community themselves. So this was a huge innovative.
Thank you very much for that. Yes, again, I think we see that theme of collaborative working with communities, with universities, with the private sector and the third sector, and the add value of these collaborative provisions, bringing the process of access to justice and working together actually to life in reality for the benefit of the public, for whom to a certain extent we are there to support and to serve. I just thought we would take a moment before we hand back to colleagues in the room here to ask if anybody who's joining us online had any contributions that they might like to make without putting anybody under pressure. I can't see any names, so I can't actually pick on anybody to make that contribution. I'm not seeing any hands up. None from online, nothing in the chat. Okay, so back over to everybody in the room here. Just wondering, we have another contribution. Thank you.
Thank you very much. Rahim Shamji, CEO of ADR ODR International. We provide mediation training, ADR training to individuals, but particularly our focus is on university sector. I have 2 points really to make. First of all, Tony, who's the director of clinics at BPP, BPP used to have a project called Friends of Mediation project. I'm not sure what form that's in right now, but the idea of university law clinics and pro bono maybe limits what we're trying to do in terms of access to justice, and also thinking about people's rights and understanding what they can do, and actually thinking about what are the processes. We heard mediation mentioned several times this morning by Master of the Rolls and the Minister. We need to really think about this as more than just an advice opportunity, but actually a skill development. And we have created a new qualification called DDRS, Digital Dispute Resolution Specialist. And so we benchmark this for law students. We're delivering it at BPP and other schools in the UK and around the world. But the second thing I think, and it's been mentioned a few times, is we need to really think about harnessing technology. Right? The legal tech space, and there are many organizations, and one I wanted to mention to you, as you're looking around the world at different models, is two companies in India, probably the foremost ADR legal tech. One is called SAMA, S-A-M-A, and the other is called Presolve 360, P-R-E-S-O-L-V-E. If you could just get your head around these numbers, between the two of them are doing 100,000 cases per month online using artificial intelligence, but real mediators and professionals helping. But there is a legal advice system based on AI to help them, which is verified by legal professionals on a pro bono basis, normally by final year students at their law schools, because they do a 5-year LLB in India. I really think we have to look at those emerging markets and countries. I think there's huge lessons to be learned. And I think the opportunity is not to limit it just so much at legal advice, but the skill of actually helping them through the process. So those are my comments.
Thank you very much. That's tremendously helpful, and I absolutely would agree with the point that you made. It cannot just be that we look at this through the lens of the law clinic and that process. It needs to be about developing those soft skills as well as the hard skills. And very interested to hear more and to do some research around those two AI tech companies in India. That sounds tremendously interesting. So thank you very much for that. Do we have another one?
Yes, thank you. My name's Jan Luber. I'm a recently retired circuit judge. I'd like to make a contribution on each of the two linked topics. First, pro bono. I'm very interested to hear about the Australian initiative to require providers of services to central government to provide the providers of legal services, central government, to allocate a certain proportion of pro bono. It seems to me that we've got an even better opportunity in this country because we have many hundreds of local authorities who commission the outsourcing provision of legal services, and each of them ought to require a pro bono element in exactly the same way as they require particular policies and procedures to be adopted in keeping with what their local authority masters want. And if we're going to do it in local government, why not also in, for example, the social housing sector or the housing associations who commission legal services, the quangos, the regulators and everybody else who outsources legal services? Every one of those contracts should be containing a pro bono element. The other contribution I wanted to make is much more controversial, and it's relating to the other linked theme, university law clinics. I'm at this workshop because I'm presently involved in establishing a university law clinic at my old university. And I was slightly troubled to hear Sue suggest that what university law clinics now need to do is to compete for funding in the wider market for the provision of legal services. I think that's, if I may say so, a step in entirely the wrong direction. The only reason we're having these university law clinics, instead of placing law students in an environment where they can see the delivery of legal services, is because there are no such environments. The example was given of Devon and Cornwall, no law centre, no advice services, and so on and so forth. The last thing we want is university law clinics competing in the funding market against those trying to establish law centres, advice centres, and legal aid services. So university law clinics, certainly valuable role, but let the university fund them, not compete for funding in the wider legal services market. Thank you very much.
Thank you. That was a really helpful comment. And I think what I was trying to do is indicate the state of the current of the higher education market. Not everyone understands in universities the law and what we offer in the same way as we do. Can I just ask which clinic it is, which university it is that? Oh, you didn't say. Okay, fine. Right, we're coming to. We've got 10 minutes. Oh, okay, we're fine.
We've got 5 minutes.
5 minutes left. Okay. 5 minutes left. Anybody want to come in before we finish? Yes, at the back.
Yes.
Thank you, Toby. So just picking up that last point, the Australian legal market is a very advanced pro bono jurisdiction, but it is just worth bearing in mind they are an outlier in having a semi-compulsory pro bono in the sense that to get a government contract, your firm has to deliver a certain number of hours. And there's obviously a question for the profession and the wider sector as to whether, if you introduce something like that, do you make pro bono essentially half compulsory when actually it's a long tradition that the profession in this country has done on a voluntary basis. So that's a question obviously that needs discussion as to whether you actually want to move down a line where lawyers feel compelled rather than encouraged as part of their professional commitment to volunteer. There's a lot more we can do to encourage law students and the profession to volunteer, but I think it's a serious question as to whether you want to introduce some sort of government or public authority mandated pro bono. So something for a big discussion perhaps. But Australia has a very interesting legal market that's worth looking at.
Thank you very much for that. I think that's a very salient comment. In response, I think what I would say is, in my holistic vision, let's say, of where pro bono should sit, should it be something that we as lawyers we see it as part of our professional duty? It's part of the rule of law that we are here to provide that service to the community. I think I absolutely agree with you. I think there's something maybe about trying to use our convening powers and our soft powers to persuade perhaps the profession to do more, rather than necessarily mandating the profession to do more. Because I take your point that would be quite a hard policy swerve, but possibly a very interesting debate for another day in terms of how we could provide more incentives or that nudging, as I describe it, to get us to that optimum state rather than necessarily mandating. So thank you for that. Very, very helpful. Yes, sorry, I've got a gentleman at the back, and then I think it would have to be our last
Hello,
comment.
everyone.
No, sorry, sir, we've just one comment there.
Hello everyone, I'm Sonal. I'm a lawyer in India, but I'm pursuing LLM human rights at SOAS. I have been working with different university law clinics in India. One area wherein we are facing a lot of problem is that the law clinic seems to be very neutral with the matters like gender, disability, or matters which does not involve corporates. So I am just looking for, like, my understanding is, how do you how do you deal with certain situations? For example, there are mining companies, there are companies who are creating a lot of human rights violations. So sometimes university law clinics does not take it very seriously. So I think there is an area wherein we actually need to put some points and we need to think on this. Thank you.